Welcome to Covered, the insurance law podcast for corporate policyholders. I'm Vince Morgan.
And I'm Claire Cahoon.
Hi, Claire.
How's it going, Vince?
Well, it's good. How are you today?
I'm doing great. We had a really fun event with the Summer Associates yesterday and got to meet some new Summer Associates. And as you know, we've got a couple of them again listening in today, which is so much fun.
That is awesome. You know, they're sitting there. I have this image in my head that they were like in a constitutional law class a couple of months ago. And they're thinking, gosh, I can't wait to get to the law firm for the summer. And I'm going to do all these cool things. And then here they are listening to a podcast on insurance law. And I mean, how awesome must that be for them?
Amazing. So awesome. Yeah. The next generation of insurance lawyers.
Right.
And, Vince, that actually kind of brings me to something I wanted to talk about with you before our interview, because when you were talking with me about our guest today, Beth Bradley, you used the word trailblazer to talk about her, which is very, very high. That's a serious word. That's a very serious word, very high praise. Sure. And I thought it was cool in the context you were talking about how, at the time that she entered the field, there weren't a ton of women who were real powerhouses in the insurance law space. And, I that got me thinking, and I kind of wanted to know how have you seen the profession change in terms of the kind of people who are in the insurance law space since you started? And, we've got these Summer Associates coming up as the next generation. How do you see it changing?
Well, that's a great question, Claire. When I started practicing law, and in fact, I met Beth before I became a lawyer, and there were, at the time, I don't know, maybe 50 to 100 lawyers in Texas, at least that I knew about, who just focused on insurance law. And I'm sure there were more, but in terms of kind of, the sort of
the relevant ones.
Typically, it was really a smaller group than that of kind of the leaders of the practice. And now it's the field has just blown up over the last few years. There still are, thankfully, a very small number of lawyers who really specialize in high-end commercial policyholder work. So I'm glad that that part of it is still pretty small, but it really has blown up. And Beth is one of the trailblazers. I mean, if you look at you see like in college football and other sports, like coaching trees of coaches who then grew other coaches underneath them, who then went on to other programs and stuff. And if you look at the sort of Beth's coaching tree, I mean, the number of lawyers that have come up under her is really an impressive number. And I think you'll see that as you see it. And you look around the practice, and there's a lot of Beth disciples, and it's a formidable crew. So that's another way to look at her career.
I'm really excited for your conversation with her. We've got some really great questions lined up. Is there anything else you want to share with our audience before we get into it?
No, I think, I'm so excited about our guest today. I think let's just go ahead and shift straight over to it, because Beth is, as you point out, a trailblazer, and really excited to have her join us today. Okay, time for our interview with Beth Bradley. Beth Bradley, how are you?
I'm doing quite well. How are you?
Super awesome. Thank you. Welcome to Covered. Have you ever done a podcast before, Beth?
I have not, but I've listened to a few. And so far, you all are doing great. Just great.
Well, it's very kind of you to say thank you. What kind of podcast do you listen to?
I listen to some political podcasts, and I listened to a bunch that had to do with COVID-19 early on, and different guests talking about the development of the science and the vaccines and where we were going.
Yeah, and I would hazard a guess that your political podcasts also covered COVID-19, because that has itself become, in some ways, a political issue. So you can find a way to merge it. Well, here on Covered, all we do is talk about super awesome aspects of insurance law. And as you know, we represent corporate policyholders here, and you occasionally dabble in that kind of black magic, but so we won't be talking about that. We do talk about COVID claims, because of course we've got lots of those, but today I think we're going to focus on some other areas. So how about we talk about insurance law? Our audience loves to hear kind of how people got in the roles that they have, right? And when I met you, Beth, you were a partner at Thompson Co. But tell us a little bit about how your career has evolved, how you got to kind of be a coverage lawyer, and then you branched out and started your firm. What is that? That's close to 20 years ago. So tell us about that.
Getting there, yeah. And I've been practicing for a lot longer than that. Decades, chapters, whatever.
Sure.
I don't know that I was a trailblazer in becoming a coverage lawyer. It was more like there was a confluence of events in the law around the time I got out of law school. And it was kind of like give it to Mikey, he'll eat anything. The firm I was working at, which was Thompson Co., discovered that I really didn't mind researching 50 states' law on the sue and labor clause. And there were very few people who would do that. So I fell into it a little bit. They gave me more because I did it. And I graduated in 1986. And in 1987, and Vince, you're a legal historian, you know this, two significant things happened. One of them was that the Ranger versus Gwynn case came out and suggested that not only was there a Stowers duty to settle placed upon insurers, but maybe they had a duty to handle the entire case in a way that was not negligent, and that anything and everything they did could be second-guessed later on. In addition, a week later, the Arnold case came out and established bad faith, or a breach of a duty of good faith and fair dealing, as we like to say. So with those two things, suddenly there was a lot more focus and emphasis on coverage as an actual practice area and not a sideline for people who did insurance defense. And as a young lawyer, that was perfect for me because I saw an opportunity for job security and a lot of research and writing, and I enjoyed that. And that's kind of how I fell into coverage. And that's around the time the late 80s is when firms first started to have dedicated insurance coverage practices. There were certainly people who did it, who were stellar at it, but that's when it started to become a serious practice area. And that happened to coincide with me.
Wow. Well, that's really interesting. I had not put those facts together. I don't know why. I've known you for many, many years and have never actually asked that question. So look at that. I'm learning something new too. So that's pretty cool. I did remember you told me that somebody just handed it to you and thought, you liked researching and you liked sort of thinking things and analyzing things, and that kind of fit. But the rest of the developments, that's helpful. And that's an interesting coincidence. So, all right. And then I talked a little bit about in the intro about your coaching tree. I'm thinking some of the lawyers at Thompson Co. that I know that you mentored, and then some that I know have gone in-house. As you reflect, kind of on, and then you've got, of course, a stable of lawyers in your current shop that you have helped train too. What's the, as you look back on kind of helping grow lawyers to become, insurance practitioners, any thoughts on that as you kind of, think about the lawyers you've worked with?
I would say it takes a certain personality to want to be a coverage lawyer.
Yeah, special kind of nerd.
Yes, but say that fondly. Fondly.
Sorry.
And it's like learning a language. I mean, and I know that you know this, Vince. You're very good at what you do. As you begin to read more and more policies, you see there is actually a logic to them, and you start to be able to anticipate how a court might construe provisions and why that might make sense. And I find that interesting, and that's why I keep doing it. And if you can find a young lawyer who becomes interested in that, then you can encourage them and train them and try to teach them that there actually is a method to all of this.
Like somebody maybe named Claire, for example.
Yes, like Claire.
Sure. Yeah. It was funny. When she got here, since I joined Bracewell about a year ago, and I hadn't met Claire when she was, being recruited and accepted the firm's offer. And, you just kind of, I guess, just accept an offer for litigation. And when she got here, they paired her up with me, and we were wondering, I'm like, what did you do wrong? Who did you upset to get stuck with me? And we quickly figured out that actually the pairing was pretty good. I mean, they were pretty smart folks who I guess knew her well enough and knew me well enough by that point to think, these two would be a good fit for each other. And everything from sort of similar snarky sense of humor to, loves to figure things out, unpack them, and come up with, different ways to look at the same thing, and so it's been really great. I'm super excited about Claire. I think you're going to hear more from her in the years to come. So stay tuned for that. Tell us a little bit, Beth, about your practice mix. Tell them, it's mostly carrier, but the occasional policyholder thing. You do some broker work. You, I think, dabble in reinsurance. Some property liability. I mean, just give us a sense for the kinds of things that are going through your office these days?
And it has cycled from time to time through my career as to what I do or what I do predominantly. And in the beginning, like every other young lawyer in that time, I did insurance defense. So I represented agents, I represented lawyers. I had the occasional product liability case, and that was interesting, and it was a good background. And then I moved into coverage. And initially, it was mostly general liability. And then I did a lot of property. Had a trial representing a reinsurance broker. That was interesting. And I had to learn reinsurance. And the partner in charge told me, go in the library and learn everything you can about reinsurance. So we had exactly two books about reinsurance, and I read them. And then we met with the client, and I showed off my wonderful new vocabulary, because the best thing about reinsurance is that it has its own vocabulary. And that was really good and interesting. So I have dabbled in reinsurance. And then I started doing a lot more of the property work, and had clients who would send me their SIU claims, the ones that were earmarked because they looked like there might be fraud involved. And those are fascinating. I mean, it's like listening to criminal lawyers tell stories. They always have the best stories. Well, those where there is fraud or there's an aspect that appears to be fraud and you get to investigate and feel like you're in CSI, that's a lot of fun. And then I moved into...
I've never seen those kinds of claims.
No.
But,
I know this comes as a shock, but there are people out there, Vince, who actually try to defraud insurance companies.
Wow.
Yeah.
Yeah. Well, we do it the old-fashioned honest way. We just try and find something in their policy that isn't quite past muster, and we go from there.
And then I've done professional liability work, business interruption, a lot of hurricane cases on commercial properties, because this is Texas, so you know that's a learning experience. You got to go through that. And then I did start picking up once I started we started our own firm, and it was smaller. And we had more of an emphasis just on insurance coverage. I was also able to take some policyholder cases, and not a lot. And, I try to pick them so that there's no conflict with either issues or existing clients or areas of practice, which is limiting. But it is interesting trying to switch sides and wrap your head around those. And I enjoy them. And then I started doing arbitrations and mediations, and I really enjoy that. And I'm hoping to move into more mediations in the next chapter of my career. But it's been nice bouncing around and seeing a lot of different areas, I think, and understanding, there's lots and lots to insurance, and you can look at one area and be there for 5 years and forget that there's all these other parts too that are still insurance. A lot of the same principles apply, but different risks, different exposures, different policy language. So it's interesting.
It's great. That's helpful. Thank you. And I think, you mentioned sort of doing more mediation arbitration work. I mean, my guess is that you'd be great at that. And partly because, I remember when you are a certified legend of Texas insurance law, right? And you were awarded that title by the insurance law section. And I remember they came to me and said, what would, I think it was one of your partners said, look, I'm about to give a speech, what should I, did I have any thoughts that, I could share with her that she might be able to use in her speech? And I said, well, yeah, Beth is the kind of lawyer that we all want to be. And it was really nice to see that make it into the speech. But because of that, I kind of figured, you'll do well in the mediation arbitration because, you have a high level of trust in people. And one of the things I was talking to Claire about is, there's a handful of lawyers that if, we make a deal on either side of, whatever, an extension, whatever, I mean, there's no need to file anything, right? I mean, it's just, yes, we made an arrangement. It'll be honored, right? You don't do that with most lawyers, and it takes an extreme amount of trust to have that level of confidence. And what is the best way that you have found to earn and give that level of trust with folks on the other side? Well, I mean, any thoughts about that?
Yes, I have a lot of thoughts about that.
Talk to me, because we love professionalism here on Covered. I mean, we take it really seriously.
Yeah, I think we're fortunate in Texas that, as you mentioned, the insurance bar is still a pretty small, close-knit bar. And the people who truly focus on that area are professionals, and they get along. And it's nice because I think that, if you watch too much TV, you can confuse aggression for skill. And I think that, if you came into a room and spoke in your softest voice imaginable, you still command respect because everyone knows you know what you're talking about. And I think that, it's honesty and communication and respect. And if you do those things and you actually know what you're doing, that you can get along with the other side. You can figure out when you have a problem or when they have a problem. You can talk about it and approach it in a way that doesn't require, yelling at each other or slamming down the phone or having sanctions hearings, which I absolutely abhor, even though I'm a 214 lawyer.
For those of our listeners who don't know that reference, that's the area code for Dallas. And what's funny is I grew up in Dallas. I started practicing law there, and then I moved to Houston. And our cities have a rivalry, right? And sometimes it is known as the 214 issue. I don't actually share that view. I think, I have no problems with Dallas lawyers because I was one. But I remember I had a lawyer call me it was like, 12:15 in the morning, or some crazy time, right? It was after midnight. She calls, and I answered the phone because I was here working, and she's like, "What are you doing answering your phone?" I'm like, "Well, it rang, and that's what I do." And she says, "Well, I'm calling to confer with you on some motion," and I'm like, "Okay, so you're calling me at midnight thinking I wouldn't be here, so that was your attempt to confer?" And then she says, "Well, I'm just glad you're not a Dallas lawyer," and I'm like, "Wait a minute, first off, I'm from Dallas, but secondly, you're the one calling me at midnight, attempting to confer when you expected me not to be here. So who exactly do you think is the problem here?" But in any event, I think that lawyers need to, be mindful of making sure that they ask themselves, am I handling myself in the way that I should be? And I think lawyers sometimes forget that, right? They just focus on what the other side is doing or thinking. And that can, be some of the problems that we run into. I appreciate those comments. And look, we don't take much seriously here. We take our work very seriously, and we take professionalism very seriously. But those are about the only things we take seriously. The rest of it is kind of, a joke a minute. But which gets me to my next one. So, Beth, I often ask our guests, especially the lawyers who show up on our podcast, and we have brokers and risk managers and other kinds of folks, but I always ask the lawyers, my least favorite kind of case is when I see two insurance companies battling it out, right? I just hate those. It's like a pox on those cases because the law invariably, obviously we don't get involved in those. We are, purely policyholder, so we don't do carrier work. But when I see carrier versus carrier lawsuits, I just hate them because the law invariably gets messed up. It's never good for anyone. I think that those cases should be banned. What do you think? Thoughts? Agree? Disagree?
I think you're just jealous because you can't be involved in those.
You got me. Really. Yeah.
And from my perspective, what always worries me is when you see a case where someone accidentally fell into a coverage case.
Yes.
And they start making arguments, but you're like, no, don't. You're wrong. That's not the right way to go. And it goes the whole way up to the Texas Supreme Court. And you're just like, oh no, what's going to happen?
Right.
Because the arguments are not the best arguments to make if you understood the meaning of the contract and the underwriting behind it and all of that. I think that there has to be carrier versus carrier litigation because there are issues like, your favorite Stowers. There are equitable subrogation cases where an insurer just has to sue another insurer. And there are allocation issues because the law in Texas has made that a thing. So there is going to be litigation over the allocation issues because there has to be. And some of it is because there are recalcitrant insurers. And, like anything else, sometimes litigation is the only way to fix it. I do think that before a carrier engages in a suit that might change the law or interpret a policy provision or create a new duty, they ought to very carefully consider that because a lot of times that depends on where you sit. If your company is primary sometimes and excess sometimes, you need to be cognizant of that. If sometimes you are the carrier who absolutely has a trigger in your year, and sometimes you're the carrier who has no trigger in your year, but the pleadings are so vague you might owe a duty to defend, you need to be cognizant of that because next time you're going to be in the other position. And I do think that sometimes carriers lose sight of that and they push for positions that are beneficial to them in that case without seeing the bigger picture. And that's where I think that there can be a problem. And we all ought to be better counselors and advise our clients that they need to consider the greater ramifications before they just try to win the one battle.
Yeah, and I agree with that. I mean, I look, I get it. I know, like Canal gives excess carriers, Stowers right against an underlying primary, who didn't settle a case, right, and expose the excess layer. The same reason that protects insureds, right, who didn't settle a case within a layer and expose them to excess judgments.
But I don't think they should sue each other for bad faith. I'm going to interrupt you there. I mean, I really do have a problem with that because it's not, honestly, I think bad faith ought to be more limited. I know that shocks you. To protect smaller policyholders, but at a minimum, it ought to be to protect policyholders and not insurance companies. So there's really no point. There's no point in insurance companies getting 18% penalties, which I don't think they can get under Texas law, but they try. Or getting treble damages against each other, because that's not what I think those statutes are for.
Okay, well, they are conduct regulating. But what if, do you feel differently about this if it were a carrier pursuing its own claim for coverage? Suppose, for example, that you're a carrier that was breached by a cyber attack and you have a cyber insurance policy and you don't like the way that your carrier has handled your claim. Do you feel differently if it's that kind of situation as opposed to, like I paid to settle a claim against an insured and we have some other carrier that owes for that same loss? I mean, do you distinguish between those?
Sure, absolutely. Because I do think that that's the conduct it's intended to regulate. But I still think that companies ought to be cautious, even when it's their own claim, about pursuing that. Because taking advantage of the law as it exists is absolutely perfectly fine. But if they seek to expand the law, they need to recognize that they've expanded it for everybody all the time.
Yeah, well, that's the part that, causes me the angst of watching carrier versus carrier disputes is, sometimes the law gets changed in ways that, aren't helpful for anyone, right? And then we all have to kind of manage it afterwards. So those are the ones that I think you guys should just go away and quietly arbitrate, right? And, figure it out and, resolve your issues. But it's frustrating when that isn't the way those get done. All right. So, Beth, we have a history here on Covered of asking, what is your craziest claim? So we've heard lots of different things. What if there's any one claim that stands out in your career that is just like out of this world nutty? We'd love to hear it.
And I have two answers. One, The answer I should give you as an insurance professional is I was involved in the Royal versus Quinnell litigation when I was a young lawyer. Mm-hmm. And it was absolutely crazy, but it was crazy from a procedural level because there was federal litigation, there was state litigation. We had the federal court enjoining the litigants in the state court. There were treble damage claims that went into the billions of dollars. And it was just absolutely crazy. And the really crazy thing is it all centered around loss of investment. Because at that time in Texas, it was not clear that sort of a pure economic loss was not property damage under a CGL policy. So there was billions of dollars of litigation over whether economic loss was property damage, which now is kind of a no-brainer. So historically, from a lawyer standpoint, it's that. But truthfully, from a personal standpoint, when I was doing the fraud claims, I had some equine mortality cases, which are really interesting.
We are with another animal case. Yeah.
They're really interesting because you could go online, and if you had a horse that was not a thoroughbred and wasn't a breeder or anything, you could just, go online, fill out a form, and insure it for $5,000 or $10,000. So there was a lot of fraud in Texas with people killing horses and picking up $5,000 or $10,000 for every horse.
That is awful.
And TDI found fraud rings actually doing this.
Oh, geez.
But this was one. It was a single dead horse, and it belonged to a woman, and we kind of suspected her boyfriend might be implicated because it showed up dead in the field for no good reason. And she was a very nice woman. And I took an examination under oath of her, and I suspected her boyfriend. And I was asking her questions about her other animals because she also had cats and dogs. And I was asking her about her relationship with her horse. And you have to understand, I have cats and dogs, and I really like them. So we were having a conversation about how she felt about them, and then also how her boyfriend got along with her cats and dogs. And it seemed to go fine, and she was nice, and we finished. And a few days later, I got a very, 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 very angry letter from her telling me that I had tried to take advantage of her and trick her by being nice to her and asking questions about her pets. Just like,
don't know what to do about that. I'm sure it was sincere.
I didn't know what to do about that, and it didn't change my my thought pattern that she was a very nice woman, and I suspected her boyfriend.
Wow.
But it was interesting, and having now and then made somebody angry, that was the oddest time I made someone angry, and kind of the most unusual development in a claim.
Yeah, well, that seems like that was misplaced, undeserved frustration with you. Tell me, did you pay the claim?
I don't think so, no.
No. Okay, well, all right. There we are with another sad dead animal case. I'm going to have to refocus that question going forward. I'm going to tell people, tell me about a crazy case that doesn't involve a dead animal, because nobody wants to hear that stuff. But thank you for sharing that with us. So Claire here, I always give her various bits of advice, and things like if an email takes more than 3 flips of the thumb, then it probably should be an attachment, right? Or something like that. And and it's random stuff about how to read a policy and how to unpack things and all these kinds of things. But part of the advice that I give her, right, is hey, look, these are lawyers that you should get to know and learn from, and they can teach you amazing things, as they taught me. And she actually had a question for you. She said, you met Vince when he was in law school. Knowing how his career has turned out, what one piece of advice would you wish you had given him when he was a young lawyer? Actually, when I was a law student. What piece of advice, looking back now, would you think he really could have used that? And hopefully it's not a dietary constraint related advice, but go ahead, share whatever response to Claire's inquiry you care to give.
Buy Apple? No.
That would have been a great one, Beth. I wish you had shared that with me, because I would have taken your advice.
I think actually, I think your career has taken some twists and turns, but I think that you have excelled at every stage, and you've come out kind of where you need to be. So I don't know that I could have given you any career advice. You've done the right things. You're respected and renowned, and that's all good. What I would tell you is practice advice, and I would tell you the same thing now, is hire good women. We seem to be good at this coverage stuff.
Sure. Well, hey, look, that is wonderful advice, and I have done that repeatedly, and it's never gone wrong. The advice I give just about any young lawyer or law student I run into is work on becoming a better writer. I think we can all become better writers. I think it's really hard to communicate complicated things in a simple way. I mean, that is a skill that is difficult to do, and it's really helpful if you can. And so I encourage our folks to, take a writing class, read good writers, and try and figure out how they can become more effective communicators, and because oral is important too, but written word is so important in so many aspects of what we do now. You don't get to go down to the court and always argue your motion or whatever, right? Sometimes it just gets submitted on the papers. And so I focus on telling people to become better writers. And I think that advice seems like it's pretty helpful, I think, to most folks. I mean, we all think we're pretty good at writing, but I think we can all be better. And I told folks, I treat writing like it's a game of Jenga, right? And you keep taking things out until the meaning collapses, and then you put stuff back, right? With Jenga, you got to rebuild the whole tower, but with Word, you can just undo, and then when you haven't got anything left to take out and anything left to add in, then I think you're done. And that's been the single best way that I have approached it. But I tell people to work on becoming a better writer. What do you think of that advice? I think that's great advice. So if you were going to tell them to read a good book, who would you tell them to read? Hemingway was a great writer. Actually, aside from just his stories are interesting, like his writing style was amazing. And he broke every convention that writers tell you don't, or, writing books tell you don't do this and don't do that. But Hemingway broke them all, and his writing is still fantastic. If you want to look for, legal writing, there are lots of good ones, but oddly enough, Cardozo, if you read Paul's Graph, right, which is a case that every law student reads, his description of the facts in Paul's Graph is a wonderful explanation of how to communicate about a case. And so Paul's Graph is a wonderful example of legal writing. So I encourage people to read that and read it, not from trying to understand what the law is, from, kind of that was laid down in Paul's graph, but just to look at it as a way to communicate and as an example of legal writing. And Paul's graph is a wonderful example of that. So that's my thought.
Okay.
All right. Well, Beth, listen, it's been really nice to have you as our guest today. Do you have any other thoughts or questions as we close our discussion here? Because we always want to give our guests the last word.
I do not. Thank you so much. Been fun talking insurance with you.
Well, it's always fun, and I look forward to seeing you again soon. But I hope that our guests have enjoyed this episode of Covered, and we'll be back with the next one. Thank you.